Good morning, everyone, and I'm going to call this meeting to order. It's the 78th meeting of the Standing Committee on Citizenship and Immigration. Here to begin our study regarding medical and admissibility of immigrants to Canada. And we want to thank the officials coming from the department today on relatively short notice especially. We thank you because there were other things we were bouncing around. And we're going to begin with an opening statement from Ms. Edlund. I just want to let the folks know on these kinds of meetings, I really give the benefit of the doubt to the witnesses to make sure they get to explain a technical point well. So if we start to go a little bit over on the questions, it'll be because I'm trying to make sure they're given time to get us all the best answers. That doesn't necessarily mean that if you start a question at 6:52 and on the clock that I let you go forever, but I am giving them some leeway on this kind of a briefing. Okay, we're going to start with Ms. Edlund's opening remarks. Thank you.
Thank you. Monsieur le Président, je vous remercie de...
Mr. Chair, thank you for inviting us here to appear before this committee. Immigration, Refugees and Citizenship Canada appreciates the committee's decision to undertake this study.
Disability policies and guidelines play a critical role in the immigration system. As a result of the increasing number of migrants to Canada and the health risks associated with migration, there is an ongoing need to assess the health status of immigrants. This screening identifies health and safety risks and helps reduce impacts on Canada's health and social systems. As the committee is aware, under the Immigration and Refugee Protection Act, permanent and some temporary resident applicants may be refused admission to Canada if they have a health condition that would pose a risk to public health or public safety, or would place an excessive demand on health or social services, which are administered by provincial and territorial governments. Health admissibility is determined through a two-stage process. First, applicants undergo an immigration medical examination, including any supplementary tests, which are performed by a third-party physician designated by IRCC. The department then performs an assessment of the examination's results to reach a decision on whether an individual is medically admissible. The department also notifies provincial and territorial public health authorities of the arrival of individuals who may require ongoing medical surveillance and follow-up for conditions such as inactive or previously treated tuberculosis. De façon générale, les demandeurs...
In general, individuals are found to be inadmissible for public health reasons if they have a highly communicable disease that could have a serious impact on other persons living in Canada. Active tuberculosis and untreated syphilis are considered dangers to the public, for example.
Safety finding considers whether a foreign national's health condition could create a danger to the health or safety of persons living in Canada. This may include certain medical health conditions that could result in unpredictable or violent behavior, such as sociopathic disorders. In terms of the excessive demand provision, although the specific requirements have changed over time, there has been some form of screening for immigrants to Canada to minimize impacts on health and social services for most of our history. Currently, under the Immigration and Refugee Protection Act, this provision applies to all applicants for permanent residency, with the exception of convention refugees, protected persons, and some members of the family class, for example, spouses, partners, and direct dependents. Excessive demand also applies to some applicants for temporary residency, where these are eligible for provincial or territorial services. L'objectif de la disposition est d'atteindre...
The objective of the provision is to strike a balance between protecting publicly health and social services and facilitating immigration to Canada, while also supporting humanitarian and compassionate objectives in Canada's immigration policy.
Are determined by a departmental officer, usually referred to as a visa or immigration officer. These officers consider the assessment of an applicant's immigration medical exam by a departmental medical official, as well as projected health or social services needs, the costs of those services in Canada, and the effect on wait lists. This entails reviewing the medical diagnosis and prognosis, the required services, the cost for services in the intended jurisdiction of residence, and, in the case of social services or prescription medication, the ability and willingness of the applicant to pay out of pocket. If the individual's anticipated costs are expected to be above the average per capita cost of publicly funded services over 5 years, which is $33,275 as of January 1st, 2017, then the individual may be found inadmissible. No specific health condition will result in an automatic rejection of an applicant. Each decision is made on an individual basis. The provision has been found by our courts not to violate the Charter of Rights and Freedoms, as it does not exclude persons based on a specific health condition. Rather, the decision is made according to an individual's likely demand on Canada's health and social services. Of the approximately 500,000 medical exams performed annually by IRCC in recent years, only 900 to 1,000 applicants, or 0.2% of all applicants, received a finding of excessive demand by a medical officer. This includes about 200 to 300 individuals needing special education services. Les dispositions relatives à l'interdiction de territoire.
The health and admissibility provisions are designed in part to reduce impacts on Canada's publicly funded health and social services systems. We recently undertook a cost-benefit analysis using data from 2014 arrivals.
Analysis was that the excessive demand provision results in avoided costs for provincial territorial health and social services on the order of $135 million over 5 years for each year of decision. That amount represents 0.1% of all the provincial and territorial health spending in 2015. As you may know, IRCC has undertaken a fundamental review of the excessive demand provision. As part of this review, we launched consultations with provinces and territories in October 2016. Departmental officials also engaged stakeholders, including disability advocates. The results of these discussions, together with consideration of public perspectives, judicial decisions, media reports, internal departmental analyses, all that will inform the development of options to be presented for decision by the government. As Minister Hussein recently stated at a federal, provincial, and territorial meeting of his counterparts, and I quote, "With the cooperation of the provinces and territories, I'm pretty confident that we will arrive at a place where we can both live up to the need to protect our health and social services from excessive costs, while also treating people fairly and including individuals with disabilities." Pour résumer, le programme de contrôle médical d'IRCC.
In summary, IRCC's medical screening program takes a risk-based approach that balances the facilitation of immigration with the protection of federal, provincial, and territorial health and social services. Once again, IRCC appreciates that the committee has chosen to undertake a study of the immigration medical screening policy. Thanks very much, and I look forward to answering your questions.
We'll begin with Mr. Tabera.
Thank you, Mr. Chair, and thank you for the witnesses for being here today. My first question I'll let either of you choose. I wanted to talk about a specific, if it's a group of 5 family, and the group of 5 have applied to come to Canada, and there's one individual within the family that is deemed medical inadmissible. Does the whole family get rejected in that application? Are they considered as kind of a one unit?
It doesn't necessarily lead to a rejection, but yes, generally if one member of a family is inadmissible for whatever reason, criminality, security, medical, whatever, then the entire family unit would be considered to be inadmissible to Canada. In the situation of medical inadmissibility, there are other avenues that can happen. So individuals can have their cases accepted on humanitarian and compassionate grounds, for example, or be provided with a temporary resident permit.
Okay. Can you tell us how many permanent resident and temporary resident visas applications have been deemed medically inadmissible to Canada in the past 5 years? I'm not sure if you have these figures on you, but if you don't, can you table them to the committee?
Mr. Chair, thank you very much for the question. We will follow up with basically the full data, but I do have brought some figures to this committee. So basically, for the year 2014, we had a medical recommendation of excessive demand of 930. In 2015, 713, and in 2016, 1,101. So generally speaking, we say roughly it's between 900,000 in any given year, which represents basically 0.2% of all applications. So just remember, though, that those are findings of medical inadmissibility, but there's a process after that point. There's a procedural fairness process, and there's basically a review by a visa officer. So the actual number of rejected applications will be significantly lower, and we will follow up with those statistics. I have a breakdown by category if you would like that.
Sure.
Yeah. Okay. So basically, in 2014, federal. I'm just using that year as a sort of an example. Federal skilled workers, we had basically 114. Quebec skilled workers, 62. Live-in caregivers, 150. Provincial nominees, 101. Parents and grandparents, 238. Other family class 6. Students, 41. Foreign workers, 36. Temporary residents, 52. H&C, basically humanitarian compassionate, 51. Unspecified, 64. And then there were basically some that reapplied in other categories, roughly 15. So that's basically the breakdown of that 930. Again, those were medical recommendations and not actual refusals. And we'll follow up with the full details. Thank you.
Okay. Is there a specific health condition that results in an automatic rejection?
No, there's not. So the health conditions are identified during the immigration medical examination process, and then that's assessed by departmental medical officers to see whether or not that condition or those conditions represent either a danger to public health, public safety, or the excessive demand provision. So there's no one who automatically has a condition that they will automatically be found to be inadmissible.
Okay. The government wants to maintain a balance between welcoming new members into society and protecting our public-funded health care and social services. So we need to try to strike a balance with that, and also understanding when a group of family does apply to come to Canada, that we remain compassionate towards the whole family, because there may be one that might need some assistance through healthcare needs, but many members of the family can be very productive in our Canadian society. So can you elaborate on the assessment that goes to determine medical inadmissibility?
Thank you, and yes, we can provide additional details in that area. To be clear, the assessment does not do a cost-benefit type analysis on an individual basis. It is an assessment based on the results of the medical examination and supplementary testing, and from which a medical officer assesses the severity of the illness, the degrees of services that would be required to treat that, which then form the initial medical recommendations that are given to a visa officer. At that point, however, individuals are able to prepare, as part of a procedural fairness step, a mitigation plan to identify if they are able to offset the costs that are related to things that can be paid for here in Canada. And so recognizing that under the Canada Health Act, individuals cannot pay for medically necessary treatment. Individuals who are applying to come to Canada can say that they would be able to offset the costs of prescription drugs or of other social services that can be provided through the market. And so this is, to the degree possible, a way of identifying their ability to make a contribution to offset those costs. Other countries have considered approaches that use something more resembling a cost-benefit analysis, specifically Australia, but they found that it was unworkable because it involved too many unsupportable assumptions as to what an individual's employment trajectory or income would be over the years following their arrival. And so they abandoned this approach.
Mr. Chair, how much time do we have?
30 seconds.
Just real quick, I read somewhere that the UK and United States have a higher threshold than our 33,000 for 5 years. Is that correct? And can this threshold be increased?
The UK and United States have differing approaches, actually. Certainly in the United States, it's difficult to argue that it's going to be a burden on publicly funded services unless it's individuals who are very low income who will be on Medicaid. And so it's more something in both of those cases that is left to the equivalent of our visa officer's discretion that is done on a case-by-case assessment. Australia and New Zealand, however, we do these comparisons with the large immigrant-receiving countries that are like us. They also have a threshold-based approach, and the dollar value of their thresholds are remarkably similar to us after you consider exchange rates.
Thank you. Ms. Rampel.
Thank you, Mr. Chair. You mentioned, Ms. Edlund, in your opening remarks that you were preparing options for the government in terms of changes to this policy. Could you provide the committee with some details on what some of the potential options would be and when you're planning to present them to the government?
So it's a bit difficult to answer that question as officials because, of course, we provide our policy advice and options and analysis to the government. And so when Minister Hussein appears before the committee later on during this study, he'll be able to provide more details. But that said, I quoted Minister Hussein in my opening remarks, and it's pretty clear from things that he said in the media and the guidance he's given us, is that he wants to strike that balance between excessive cost and making sure that that continues to be part of the package, but also looking at fairness and equity for applicants and treating people reasonably, and making sure that individuals and he said publicly as well that the current provisions seem to be out of step with societal mores in terms of how we deal with individuals with disabilities and the contributions they can make, and so that will be part of our package.
You mentioned that the options that you're preparing for the government were based on an aggregation of feedback from a wide variety of stakeholders. So in terms of Mr. Hussein's comments regarding a lack of fairness or a need to strike a balance, what feedback came forward from those consultations in terms of specific points that would suggest that there isn't fairness right now?
Mr. Chair, to answer that question, we received feedback from a wide range of stakeholder groups, and we also considered other activities that the department was undertaking in terms of its outreach and contact with Canadians. And so in terms of the identification of concerns about a lack of fairness, certainly disability advocacy groups were quite vocal in identifying their concerns in this area.
And what were their concerns?
Disability advocacy groups see this as being discriminatory against individuals with disabilities.
Has there been any
despite
court
that
rulings
being
to
the
date?
position that this is
Just due to time, I'm sorry for interrupting you, just nature of the beast. Has there been any court rulings to date that have suggested that our current policy is discriminatory?
no, there have not.
Thank you. I'm wondering if you can also provide a breakdown by year over the last 10 years in terms of the types or classifications of either diagnoses or symptoms that have been used to deem somebody medically inadmissible by number of case. And if you don't have that data here, if you can provide that to committee.
We will provide that data.
Thank you. The other component that I wanted to touch upon was the figure of $135 million over 5 years by the start. Could you provide the committee with, rather than over 5-year perspective on cost, the cost-benefit analysis sort of on a by fiscal year going forward based on your analysis, just so that we can have an exact cost breakdown by fiscal year on if there was a revocation of this policy, what the actual cost would be, and what assumptions you've made in terms of the input costs to get to that figure.
The input costs in terms of the amount of effort by the department were relatively low.
Sorry. I'm just asking you, to be clear, what I'm asking you to table with committee is a forecast. So just to clarify, how many years did you forecast into the future right now in your cost-benefit analysis?
It's that we used 1 year of representative data in order to conduct the cost-benefit analysis.
Okay.
And the determination is based on a 5-year cost estimate.
Okay.
And so we use those cost estimates as
So
the
could you
basis
provide for committee,
the savings.
based on that analysis, I'm interested in 2 figures, by year, the amount of cost that you're projecting if this policy continues, and then how did you come to that figure, right? So I'm not asking for your time to be calculated. I'm asking for cost of provincial healthcare systems, medical, anything, just so that we can, as committee members, get a sense of what costs are associated with this analysis.
The approximately 900 and some odd cases were reviewed by an analyst to identify the estimated cost savings from each of those cases, and we summed that up as being the estimated cost savings to provinces for that year. Given that we were using a year that had roughly balanced numbers in terms of the different types of conditions that were under consideration, our assumption would be that for each year of decisions, you would generate approximately that same order of magnitude of savings. So between $120 to $150 million per year, as you sum that out over each year of decisions.
In terms of other assumptions that you put into that figure, are you assuming other costs or other inputs, such as the amount of taxation somebody might pay when they come to the country? Like, are you looking at any sort of net economic benefit in terms of costing that out as well, or is it just straight up the figures around what their potential cost to the healthcare system would be?
It is straight up avoided costs for the healthcare systems. Net economic benefit would have been too complex to undertake for the analysis.
Okay. Can you also provide us with the breakdown by country, let's say over the last 10 years as well, of how many cases are rejected due to medical inadmissibility?
We will get that data.
Sorry, just to clarify, Mr. Chair, is that by the nationality of the applicants?
Yes.
Okay, thank you.
Do you have, can you provide us a little bit of background on how doctors are selected to take part in these exercises, how the department would source physicians?
Okay, so I'll start and then I'll refer to Dr. Saeed. I referred in my opening remarks that we have what are called panel physicians that are impaneled by the department according to a set of different standards. And we do quality assurance and various checks on those medical professionals to make sure they're going to do the immigration medical exam under the standards that we set out for them. And then we have our own medical officers who are departmental staff who'd actually do the actual assessment.
And is there a certification process or sort of a quality assurance process that the department uses?
For the panel physicians, absolutely, that we do monitor the activities, sometimes in combination with a country like Australia, because we share some of the same panel physicians.
Okay.
So we actually monitor those activities, and again, to make sure that they're doing things properly as they're supposed to. And then if there are instances where there's a problem or a serious problem, we actually have let go some of they're not our employees, so we don't let them go, but we no longer allow them to be our panel physicians.
Thank you very much. Just before we go to Ms. Kwan, could I clarify one thing that's come up in both rounds of questions? In your opening remarks, you state it costs on the order of $135 million over 5 years for each year of decisions. That language is eluding me because it says two different things. It says $135 million aggregated over 5 years, but then it says for each year of decision. And Mr. McKinnon's remarks just seemed to indicate it was $135 million a year, and I'm just trying to understand that.
Point of clarification, Mr. Chair. Thank you for raising this. Just to clarify what data I was trying to get out of the witnesses, we have the same concern. So if it's $135 million over 5 years, but it's like a rolling scale, what is the actual cost per year? That would be a more meaningful figure.
That's what I'm trying to understand, because I don't understand the syntax of that sentence.
Thank you, Mr. Chair. And to be clear, it is that each year of decisions, in essence, generates a 5-year profile of avoided costs for the provinces. Because it involved a case-by-case review by an analyst in order to conduct the cost-benefit analysis, we used only 1 year that was an exemplary year in terms of the levels of immigration, in terms of, all of the source countries, those sorts of things. And so we're using that as the assumption that savings will be for each year of decisions on the order of $135 million over that 5-year period of time. But then each subsequent year of decisions will generate a similar 5-year profile of savings in turn, as Ms. Remble indicated.
It is difficult for us because why 5 years and why not 10 years or 20 years? And so it would seem to me a year of decision would be 1/5 of that amount per year. But it could be 25 years or 4 years or 2 years, or the person could die in 6 months.
We used a 5-year profile because that is the basis of the policy, that the assessment is done using the estimated costs over a 5-year period for an individual's given health condition.
Would it be fair to say $27 million a year for maybe $5 million, or no?
It's more that with those rolling 5-year profiles, in any given year, you will have 5 years worth of decisions that are generating savings. And so your savings will be on the order of $135 million, perhaps as low as
of the years.
120.
It just depends on the vantage point you're trying to get from. That's all.
Yes.
If you're a province, you're thinking it's $27 million a year. No?
If you're a province, you're thinking is $27 million from this year plus $27 million from next year.
From next year.
And
Absolutely.
so you're probably aggregating it as being roughly 150.
Sorry. I find it difficult language, but not too bright here. Ms. Kwan.
Thank you very much, Mr. Chair, and I thank the officials for their presentation to the committee. Mr. Chair, I have a series of questions, and I know that we're limited in time, so what I'm going to do is to put these questions on the record and ask the officials to undertake to provide answers to the committee with respect to them. And I think what's underpinning all of this, one of the most important questions is the information and the evidence to which the officials can provide to us on how the government sets the current cost threshold for excessive demand. I don't believe anyone's disputing the information provided by the Canadian Institute for Health Information, but I would like to get to how this figure is being derived at. So to that end, Mr. Chair, I would like to ask the officials for the following information. One, how does IRCC set the cost threshold for excessive demand, particularly for social services? And it is my understanding that the government uses a figure of $356 that is spent on social services per capita each year. But where did that figure come from? And whether or not that is the correct figure. Does the current review aim to more clearly define the social services considered when setting the threshold for excessive demand? And if yes, how will this be accomplished and accounted for to ensure transparency? What about applicants who have been denied in previous years for amounts very near to this threshold? We've heard the number of people who are being assessed in this context. So how many people who've been denied, and for those who've been denied, and if their threshold was very close to this amount, does IRCC intend to launch a proactive review of these cases, or at least provide an avenue for applicants to reapply without incurring additional costs? We have seen, at least anecdotally, major inconsistencies in how applications involving medical inadmissibility are reviewed and handled depending upon the medical officer or immigration office responsible for a particular file. In some cases, medical officers fail to provide any sort of cost estimate to applicants when stating that they may be deemed inadmissible in procedural fairness letters. And apparent violation of existing case law, specifically, Mr. Chair, in the Sapru versus Canada 2011 case, which requires applicants be provided with cost estimates during the procedural fairness process so that they may put forward a reasonable challenge to the government's claims. And to that end, does the officials acknowledge that there are problems in terms of how applicants are handled by one officer or office versus another, and that these problems include significant inconsistencies in how medical officers review the anticipated costs of care in Canada? And has IRCC's review of medical inadmissibility include a review of these inconsistencies? And if yes, what efforts has IRCC taken to ensure medical officers are aware of and adhering to existing case law regarding procedural fairness? The Canadian Bar Association has recommended that the processing of cases involving medical inadmissibility be centralized in Ottawa so that these more complicated cases can be given the care and attention they deserve. I wonder whether or not the officials agree, and if yes, what is being done to make this happen? If not, why not? We understand provinces are being consulted on a range of possible policy changes, including the possibility of expanding groups of persons exempted from these provisions, something that is currently limited to refugees and protected persons, Mr. Chair. Is this true? And if yes, what groups is the government considering to make exemptions from medical inadmissibility and excessive demand provisions? Disability advocates from across Canada have spoken out against these provisions, saying that medical inadmissibility discriminates against people with disabilities, forcing them to go through a process able-bodied persons do not have to. Does the officials or the government acknowledge this policy unfairly discriminates against persons with disabilities? Specifically, what I'm talking about is the process of forcing people with disabilities through a separate and segregated process of medical review by virtue of the fact that they have a disability. This, to me, is a textbook case of discrimination. And the outcome, whether admitted or not, is irrelevant in that the person with disabilities are discriminated against prior to these decisions are ever even being made. So to that end, does IRCC intend to make persons with a disability, particularly dependent children of economic applicants, exempt from these provisions? If yes, what disabilities will be exempted, and how will the government determine the list of exempted disabilities and conditions?
Thank you for the questions. I'll touch on a couple of them, and then we'll provide written responses to the others. So, Mr. Chair, the question was asked about how we establish the cost threshold. We have two different component parts to that cost threshold. So the first is looking at the annual report from the Canadian Institute of Health Information, and it provides an annual look at per capita usage by Canadians in relation to health and social services. And so in 2017, that number was $6,299. A second component of that is then we look at the definition of excessive demand and our definition of social services, and we compared the types of services that the Canadian Institute for Health Information actually covered, and some of the parts of our definitions of social services were not covered by the Canadian Institute for Health Information.
I wonder if I can interject, if the committee can get your definition in writing then of what you define to be social services and get that list from you.
Absolutely. It's actually part of the regulations. So it's just a defined term in the regulations. So some of the pieces that are not covered in the Canadian Institute for Health Information for social services, for example, global home care, some specialized residence and residential services, special education services, social and vocational rehabilitation services, and personal support services. Those are all part of our regulation, and the Canadian Institute for Health Information doesn't cover those. And so what we did in 2004, we undertook a study by looking to sources such as Statistics Canada, Health Canada, speaking with provinces and territories about their data, and then calculating those missing services that aren't in the CIMM numbers, what that actually turned out to be. And then, so we provided that baseline in 2004, and we've actually increased that by the cost of inflation every year. So in 2017, that's now $356.
Can the committee get that study so that we can actually review what was undertaken, so that we can actually have that information?
The baseline study?
Yes.
Mm-hmm.
Thank you.
I think that's your time. You'll get another shot at this. Ms. Zahid.
Thank you, Chair, and thank you to our witnesses. You mentioned in your opening remarks and gave us some numbers of the people who were medically inadmissible. But I would like to know that over the last few years, what percentage of the negative decisions due to excessive demand were overturned by either a ministerial intervention or the federal court or the IRB?
So the numbers of cases that are overturned, I don't think that we actually have those numbers with us at the moment, but there certainly have been decisions by the federal court, by the Immigration Appeal Division over the years, some of which have upheld the medical inadmissibility finding, and some of which have overturned the medical inadmissibility finding. So we can do further research and provide that to the committee. I also spoke about the possibility, in response to an earlier question, of people getting, sometimes with the medical inadmissibility recommendation by the medical officer, then individuals provide information, for example, in relation to social services, and they satisfy the visa officer that they actually are not inadmissible. They are not, and so their case, that happens there.
Yeah,
some people withdraw their applications. Some people end up with temporary resident permits. Some people are granted visas on humanitarian and compassionate grounds. So there's kind of a range of results that can happen after the initial medical officer recommendation.
So is it possible to get some numbers on that?
Yes.
And my next question is, when a decision of inadmissibility due to excessive medical demand is rendered, the applicant has the opportunity to submit a plan to show how they can mitigate the impact. Over the last few years, how many and what percentage of these plans have been accepted?
I think in terms of the statistics, we'll have to follow up with the statistics, but I'd like to ask Dr. Saeed to speak to the process around the mitigation, how the mitigation plan is actually considered.
Thank you very much. The mitigation plan is submitted as part of the procedural fairness given to the applicant, whereby they will propose, first they can challenge our diagnosis. Secondly, they can provide a detailed plan which includes how they're going to defray the cost of that service. Because as we said earlier on, it's not a medical condition that renders them inadmissible. These are the services or health services or social services. So if they have a detailed plan and we look at the feasibility of the plan, the practicality of the plan, the applicability of plan in Canadian context. So if that is done, we provide our opinion back to the visa officer to make the final decision.
So would you have any numbers that how many of these plans have been accepted over the last 2 or 3 years?
That number we can provide you later on.
Okay.
We don't have it right now.
Okay. My next question is on your opening remarks. You mentioned that with the exception of convention refugees, protected persons, and some members of the family class, that is spouse, partners, and direct dependents. I would like to get some more clarification on who is exempted, because we hear stories like there is a live-in caregiver whose son was rejected because he was disabled. So, if we can have some more clarity into who is exempted and who is not.
So the exempted groups are convention refugees, such as resettled refugees. They are protected persons, so people found to be refugees in Canada. And then some members of the family class, so the close family members. So if I were sponsoring my spouse and my dependent children, they would be exempt from the medical inadmissibility provisions. We still do immigration medical exams because we want to know from a public health or public safety perspective whether there's something that we need to be concerned about. But then there are folks who are not exempted. So the kinds of cases you're talking about tend to be cases where they're economic immigrants, and it's either the principal applicant or one of the dependents of that economic immigrant who has issues, who has a health condition that then raises concerns around excessive demand. So it might be a live-in caregiver, it might be a federal skilled worker, it might be a student, etc.
But would not they be considered as dependents? An 18-year-old child will not be considered as a dependent of that live-in caregiver?
They're considered as dependents, but they're not exempted the way close family class members are under the policy as it currently stands.
So close family class, like if, for example, today I sponsor my husband and my 2 kids and one of them has a problem, they would be exempted.
Yes.
But for the live-in caregiver, that will not be exempted. They would come
Yes.
under. Okay. My next question is that does anything in the evaluation process consider the economic benefit of having the family in Canada as permanent residents and the contribution to our economy that would be lost should the family be denied?
Under the current policy, no. So that's considered as part of selecting individuals to become immigrants to Canada, that selection decision. But the actual admissibility, medical, criminal, or otherwise, don't then factor that back in again. We don't have that net economic benefit test that Australia tried to do a few years ago and found it was too complicated.
Okay. How much scope do officers have with regard to the interpretation of Section 38(1) of the IRPA? When were the most recent ministerial instructions issued, and have officers been told to interpret the Act strictly, or they do have some more flexibility while making their decisions?
So there are guidelines or instructions, program instructions, I think they're called, that are provided and updated on a regular basis. So we could look and see, particularly in the medical admissibility side, when those were last updated. Visa officers look to apply the Act and the regulations as they are written and as they have been interpreted by the courts, and we provide guidance to them to say, here's a recent court decision, we need to modify our behavior and do this and this and this instead. So, for example, when the Supreme Court of Canada made a very important decision in 2005 in a case called Hillowitz and de Jong, we modified the way in which we did medical admissibility screening at that point, and the instructions were provided to officers and training was provided, etc. So, there's always, the visa officer then is looking at the mitigation plan that's been presented, is looking at humanitarian and compassionate considerations, so there is those areas of flexibility.
Right.
That's it.
Okay, thank you.
Thank you. Mr. Soraya.
Thank you to the panel coming out. I'm still not crystal clear. Is the $135 million per annual, or is it $27 million per annual? The cost is the $135 million per year, or?
It's that at any given time, for the provinces, or from a provincial perspective, there's 5 years' worth of decisions that are in play, right? And so if we pick this year, 2017, then decisions from 2016, 2015, 2014, 2013, and 2012 are all in play. Each of those years will generate a 5-year profile worth of savings. And so, as Ms. Rempel suggested, it's like a rolling amount that goes across those years. So from the perspective of the province, they're getting 5 years worth of savings.
So 5 years, $135 million.
Roughly speaking, recognizing that that's an estimate based on 1 year of data.
Yeah, so we looked at the data from 2014 as being a representative sample, but in 2012, perhaps the profile of those people who were medically inadmissible and the costs of health and social services for those particular conditions might be different from 2014.
When we said 27 million or 135 million, 135 million over 5 years, this include the medical cost, education cost, social cost, or any other cost in it?
To be clear, it's an assessment against the basket of services that we have defined in the regulations, right? And so it is direct healthcare costs plus, I'd have to dig through my binder to find the list of the specific things in the regulations. There have been misperceptions in the media recently where, for example, they were saying, why aren't you calculating in social assistance costs or social housing costs or the amount of the Canada Social Transfer? But these amounts are out of scope according to the regulations. It's strictly the basket of services that are directly related to medical diagnoses. And so occupational therapy, behavioral therapy, long-term care, these sorts of costs are the ones that are considered in there.
So these costs are on top of these $135 million?
No, those are the ones that are included in there. It's that social assistance or social housing are out of scope for this decision because we can't forecast whether or not somebody is going to be poor on arrival in Canada. It's strictly speaking healthcare plus the immediately affiliated social services that we have in the regulations.
How much of this cost is borne by the provinces versus the federal? It's all clumped in together?
The estimates are based primarily on the assessment of the individual conditions and the expected costs that those will impose on provincial services. And so the estimate of savings, on the order of $135 million from each year of decisions, would be what we would expect the provinces would have to bear if these individuals were allowed to be admitted to Canada.
Ms. McKinnon, when this cost threshold was developed, what year, when was this developed?
I'm not certain of that. It's been around for many, many years that the average per capita cost of for Canadians for these services was used as a basis.
How often do you reassess it?
The amount for healthcare costs adjusts automatically because the Canadian Institutes for Health Information reports this as an individual piece of data each year. And so just as we were walking on our way here, Dr. Saeed advised me that they're ready to publish the estimated cost, the adjustment, for the next year based on revised population estimates and the total healthcare costs for Canadians for the previous year. So that gets adjusted on an annual basis, and then we also adjust the amount for the social services that aren't included in that estimate for inflation on an annual basis, using the inflation rate for the health sector as opposed to the general CPI.
A question for Mr. Saeed. Mr. Saeed, where are these physicians located? Throughout the world? Are they in Canada?
You're talking about the panel physicians
Yes.
who conduct the medical examinations?
Yes.
They're all around the world, in each country, and in Canada as well, designated by IRCC. So they're all around, everywhere.
How often?
I'm afraid I need to end you there. Go to Mr. Sarai.
Just
We'll be
going
around
on.
another tour.
Thank you, panel. Just to clarify, the $33,275 over 5 years, is that indexed every year by inflation, or has that number been established some time back?
It's that the health component of that adjusts automatically each year. The smaller amount, the $356, that's for social services. We do the adjustment based on inflation, but the amount for healthcare costs that's reported by CIMM gets reported each year, and in effect, because of that reporting, it self-adjusts for inflation each year.
Okay, so when was that established, the original number, do you know?
I'm not aware. It would have been probably more than a decade ago.
Okay.
The current definition in the regulations date from when the Immigration Refugee Protection Act was passed, and so that's 2002.
What are the current parameters for discretion when, say, a family is applying and one person has a disability and they're allowed, there's a discretion, as you said. What are the conditions or parameters of that discretion?
Well, I mean, there's the usual parameters that an officer has in making a decision. So as I spoke earlier, they're looking at the response to the procedural fairness letter that was sent out, where the family may dispute the medical condition, may dispute the prognosis, may bring in their own specialist reports to bear in relation to the condition and the expected health and social services that the individual may need over the course of the next 5 years. And for the social services side, then, after the Supreme Court decision in Hillowitz and de Jong, they can present what are their mitigation strategies for not having not having the same impact. So, for example, someone who is going to be employed in Canada and that employer has a healthcare plan that will cover their expensive prescription medications, that could be a mitigation plan that then the officer would take that into account to say, okay, that's that expensive medication is covered off by your health care plan, I don't need to look at that anymore. And so I find that you're not medically admissible.
And how
and
many
then generally, just temporary resident permit, humanitarian and compassionate, those are powers that officers have all the time, as does the minister.
And how many applications based or apply for that discretion annually?
We could try and get the numbers for you in relation, because I mean, there's thousands of people who apply for humanitarian and compassionate consideration writ large every single year.
I'm talking just
but
on
just
the medical.
Specifically in medical, we'll see if we can get that.
And then
data for
also,
you.
how many of them get approved?
Yeah.
So to see the ratio of how many people apply, my understanding is very few who apply for discretion ever get through, and that's or their mitigation plans ever get approved. So I'd like to know if the percentage of that, if you can get that in a timely manner. Are there other countries that have a bond or a mitigation guidelines that have been considered successful, specifically in Western countries or developed countries, or Australia?
Do we know about mitigation plans?
We'd have to explore that more.
We'd have to look into that more in terms of, do other countries like Australia or New Zealand have mitigation plans as part of the way in which they do medical admissibility decision making?
So you're not aware of any that? No. And what's the difference between, my colleague asked earlier that understand for a live-in caregiver, if their family member has a disability, they would be excluded, barring any mitigation. But a family class, you're saying it would not be excluded? And what about other economic categories or other economic immigrants? Would they be excluded, like the entire family, if one person was considered inadmissible under these guidelines?
It's the balance that we try to strike between humanitarian considerations, family reunification, which is why certain categories of applicants are exempt from the provision, versus that concern about excessive protecting social and healthcare services that are publicly funded. So it's the balance between the two. So every economic immigrant who applies to come to Canada with his or her family, they will be medically assessed. They will go through immigration medical examinations. They will be assessed, and if one of them is found to be inadmissible, they don't benefit from that same exemption as the other, as the close family class members, for the family reunification purpose.
Yeah. I'll pass.
I did want to give you an extra 10 seconds, just
The
for the
previous
record.
chair was more liberal.
Well, quite, indeed.
Time.
Mr. McGuire, you have the floor.
Thank you, Madam Chair. I just wanted to check again on the provisions that you've had here. You mentioned there's approximately 500,000 medical exams performed annually by IRCC. Does that mean that there's 500,000 individuals that have applied? Is there one exam per individual, or are there multiple exams for individuals? Or
So, for example, if a family were applying to come to Canada, all the family members would go through the immigration medical exam, right? So it's not a case. It's the entire family. That number of 550,000 medical examinations goes up and down year over year, depending on the number of applicants, depending on how many temporary residents need to go through medical examination process, et cetera.
And maybe this is what you were referring to, Mr. McKinnon, but can you provide a little bit more expansion on the definition of excessive demand?
The definition of excessive demand, and right, I've got two pieces of paper that have the legislative provision. So in the regulations, it specifies that it's a demand on health or social services for which the anticipated costs would likely exceed average Canadian per capita health services and social services costs over the period of 5 consecutive years immediately following the most recent medical examination. The definition of health services are the health services for which the majority of funds are contributed by governments, services of family physicians, medical specialists, nurses, physiotherapists. Social services in the regulation says any social services such as home care, specialized residence and residential services, special education services, social and vocational rehabilitation services, personal support services, and the provision of devices related to those services. that are intended to assist a person in functioning and for which the majority of funding is provided by governments. And so it's a very specified basket of services that we're looking at. To interpret that, it's the ones that are directly related to a medical diagnosis.
Thank you. If you were looking at a situation where a person or a child was physically disabled and had some mental incapacities as well, and required a teacher assistant full-time, as an example, would that automatically be a situation where you would reject that applicant?
I'll forward that question to Dr. Saeed because he conducts the medical assessments on those sorts of
Thank you.
grounds.
Thank you, Doug.
Yeah, and once again, I'll say that it's not the disability or it's not the condition that will render them inadmissible. We look at the severity of the diagnosis, the frequency that they will require those services. So if an extra teacher is required, yes, that will increase the cost of social services for that particular applicant. Or if they require speech therapy, occupation therapy, or other therapies on a regular basis, so that does make them, or potentially can make them inadmissible.
Yeah, and then therefore the whole family would be rejected.
That's correct.
Yeah, yeah. This is a situation I think that arose in my office before I became a federal member of Parliament, actually, and it is a situation where I believe a whole community ended up looking at the net benefit to having this person in their community. And I know we've talked about a little bit about the net benefit here, and it's a bit difficult to calculate, I understand. But this whole community wrote letters of support, just about every community organization for this individual, and it very much was accepted. And the reason they did it is because I come from mainly a rural area, a very, very big shortage of nurses, and a very qualified nurse was the mother of this child. And they needed her in the hospital more so than the costs of the rest of the care that this person was going to have. And eventually, we were able to be successful in having this family there. And they've got 3 other children in the school. There's all that taken into consideration that are quite normal in the school. And so I'm just wondering if there's any movement to look at, maybe it's not just a hard and fast net dollar cost, but to a social net benefit for a person of this type in a community as well.
So we do have a bit of a process that's used on an ad hoc basis, particularly for provincial nominee cases, where the province will come forward to us with exactly the kind of situation that you're describing, that there's someone in a rural community who is very important to them, to their economy, to their health services that are provided to the community. And they will write a letter to the department saying, we recognize that there may be medical admissibility issues and excessive demand. We're telling you we fully support this individual and the family in our community. That's put in front of then our decision-making officers, and what frequently happens at that point is the family ends up with a temporary resident permit. And once they're on the temporary resident permit for 3 years running, then they can be granted permanent residency with no further look at the medical admissibility. So we do have that process now that provinces will come forward with those letters of support.
I'm afraid I need to cut you off there. I didn't really want to because I liked your questioning. Mr. Whalen.
Thank you very much, Mr. Chair. I have to say that, this is all very interesting, and thank you for coming and giving us this tutorial on how the medical exclusions work in the Canadian immigration system. But I have to say, I feel very sheepish just even talking about it. I mean, from a moral perspective, I don't know where the objective of the provision explicitly recognizes the sanctity of human life and the equality of all people in our immigration system. So it just feels to me that doing a cost-benefit analysis in advance on human beings and whether or not they should be in Canada, just sort of, it makes me very morally squeamish. I think, when I look at this, I think these are horrible things to be measuring, so I'm sorry that you guys had to go through this. In terms of the overall broader Canadian population, how many, sociopathic disorders have you guys seen in the applications as compared to the general Canadian population? No, but I mean, there's measures for this. I mean, what, percentage of the Canadian population is sociopathic disorder, and what percentage of applicants are being excluded on that basis?
Very few are excluded on that, and that's not based on the cost basis. That's based on threat to public safety. So if they have any aggressive behavior, violent behavior, so they're deemed inadmissible based on that, not on the cost basis.
Okay. In terms of active tuberculosis and untreated syphilis, do you have numbers of those compared to in Canada? How much is being rejected? These are the three that you sort of highlighted here, so I assume that you might have done some extra digging on those items to decide to present those three.
We do have data related to this. The number of outright decisions of inadmissibility for these conditions are extremely rare because the practice of the department is to, as we call it, further or put on hold the application, right? And so an individual who is found to have active pulmonary tuberculosis from a medical examination in their home country, they're advised of those findings. And they're also advised that we can put the application on hold while they get treatment for that condition. They can return, have a subsequent medical examination, and assuming that that finds that the treatment is successful, then they're admitted, but with the requirement to report to the provinces for medical surveillance, because there is a risk that that tuberculosis becomes reactivated over their lifetime. And so, again, the numbers of people found inadmissible for these causes are extremely small.
So when you're reporting these numbers back to us, I know we've been asking for rejections. Maybe you can also include the numbers of on-holds as well, so that we have a sense of how much the application and the timelines are being impacted by these types of screening, rather than them coming to Canada and being treated in Canada. In terms of these averages, so if you have a family of 5 that's coming, does each individual person have to meet the threshold, or does the family of a group have to meet a threshold which is 5 times the dollar value if there's a family of 5, for instance?
It's each individual.
So really then the threshold, and the threshold, is it based on 2017 cost of services, or is it based on some point in time in the past? Is it rolling forward, or?
So the majority of the costs annually comes from the Canadian Institute of Health Information.
Okay.
So that's the one that's updated once a year.
Yeah.
And so for 2017, that was $6,299.
Okay.
And so they look at the per capita cost of Canadians' usage of health and social services, and they do the math, and that's the number they end up with. In
So Canadians have this big, broad curve of costs of
Yes.
medical care, and here's your average point. And immigration, anyone who wants to be an immigrant to Canada has to be, basically, I mean, there's all these other things, but has to be in the top 50%. We're not going to take immigrants that meet the overall Canadian threshold and represent what Canada looks like from a medical cost perspective. We're only going to take immigrants that beat the Canadian average.
Yeah, I mean, it is the Canadian average.
And not only that, even within a family might totally blow out the Canadian average, but if one of their members doesn't meet the Canadian average, then the family gets excluded.
Yes.
Okay, so I think my questioning is done.
Thank you. Just because you have a few seconds, I'd like to use, just in your remarks, you said, we recently undertook a cost-benefit analysis using data from 2014 arrivals. What did you count as the benefit? What of the cost-benefit analysis? I understand the costs. What were you counting as a benefit?
To be clear, for the cost-benefit analysis, the costs were largely the processing costs to the department, plus litigation costs, plus similar costs that were imposed on us like that. The benefit was the estimated savings to provincial and territorial health systems.
Okay.
And so it's
okay. So no benefit to society, like that. That when I read that heard that in the remarks, I assumed you had done something similar to Australia to look at the benefit of immigration, as Mr. Whalen was just saying, but that has never been included.
No.
Okay. Thank you, Ms. Kwan.
Thank you very much, Mr. Chair. And I'd like to just follow up on other questions. So with respect to processing time, for each of the categories involving cases of, I guess, quote-unquote, excessive demand. Can you tell us what is the average for that, and how many families have had to do more than one medical because of the long wait time in getting the application processed?
Mr. Chair, we can have a look in terms of the processing times when medical inadmissibility is an issue that has been raised by the health condition, by the immigration medical exam, because there can be furtherances. There can be, as my colleague alluded to, there can be someone with active tuberculosis goes through a period of treatment, and so that counts against the application time. And that the treatment, which I'm not very sophisticated about, Dr. Saeed could undoubtedly speak to this, that takes place over the course of a period of time, and then the application is picked back up again. Part of it will depend on how quickly the individual applicants go for the medical furtherances. If there are further tests that are required from other specialists, then it's in their hands as to how quickly they do those tests. Your second question about people redoing medical examinations, I think I believe would relate more to individuals who have been issued a visa with a valid medical examination, and they haven't been issued a visa yet. Pardon me. Let me get this straight. Their application is in process. They have a valid medical examination. They have not yet been issued a visa. The medical results are good for a period of 1 year. And if they don't get the visa within that 1 year period, then they have to redo their medicals.
Yes, so if I can get those numbers from the officials, if you can undertake to provide that information to us, that would be greatly appreciated. I have two specific cases that I'd like to bring to the attention of the officials, just by way of a snapshot of the examples. One is a publicized case, Mercedes Benitez. She made her application in 2010. It's been 7 years really, since she's been waiting for this to be processed. And with respect to her case, it's actually involving a son who has a disability, an intellectual disability, so it's not TB or anything like that. And her application is in process for 7 years. I have another case of another individual, Monica Mateo. She made her application in 2012. It's been 5 years since she's made the application. And again, it's not contagious diseases or anything like that with respect to her daughter. And in fact, in her case, her employer has even offered to say she would cover all expenses related to her daughter if there were to be excessive demands to be determined. Her employer has submitted her bank statements for verification. Still, they are waiting. There is something wrong with our system, the way in which we're treating individuals as such. When the officials say that this is not an issue around discrimination and that people's rights are not being violated in accordance to our charter, the question that I want to put to the officials and to the government is this: the process in which you're making people go through because of their disability, is that not deemed to be a violation of our charter? Because any other person would not have to undergo this process. Only people with disabilities would have to undergo this process. And that is the argument to which the associations working with people with disabilities are advancing. So I'd like to actually have the officials comment on that.
So this matter's been considered by Canadian courts over the years, and there has been many attempts by the private bar and by disability associations to advance that argument that there is a charter violation, whether under Section 7, right to life, liberty, security of the person, or under Section 15, the equality provision. And there has been no court decision that has supported or found that there is a violation of the charter. Are these difficult sets of circumstances for the families and for the individuals? Absolutely, but they have not been found by Canadian courts to reach the level of a violation of the charter. That said, I think it's pretty clear from what Minister Hussain has said that he wants us in our fundamental policy review to be actively looking at these kinds of questions and be addressing them, and that's part of the material that we're looking at.
I need to end you there. I actually got 5 instead of 3 minutes, just to let you know. We're going to now start round 3. Witnesses okay? Do you need a break? You're okay? Mr. Nandasangari for 7 minutes.
Thank you, Mr. Chair, and thank you, panel, for being here. And I actually want to just pick up from where my colleague left off. So one of the concerns is that we are processing on medical admissibility happens at the stage where we're ready to actually process the application. So someone would have filed an application in 2010, and 6-7 years later, they're going to be assessed. So we have the family essentially waiting for upwards of 5-7 years to get a decision from the department with respect to admissibility, and then they go through the process, which could actually drag on, and potentially 8, 9, 10 years later they find out, well, they're not admissible to go to Canada. How do we ensure that, or what can we do to ensure that this assessment perhaps takes place ahead of time? So that the fact that somebody's waiting for 10 years and at the end they get they're not allowed to come here itself, I think it's highly problematic. So how do we make sure that this kind of assessment could happen ahead of time, so that family doesn't have to wait for that long?
From a processing perspective, we have at times done what are called upfront medicals. And so that's before someone actually applies. They do their immigration medical exams. Since we've instituted, though, our electronic examination of medical examinations, it's called e-medical, what we used to see as lengthy delays for the medical examination and assessment process, that's no longer the case.
Just to clarify, the delay is not the medical itself. The delays are processing, which and the medical actually takes place at essentially the last phase of this. So the question is, can upfront medical, is that something that's available to everyone, or is that by invitation, or is that by someone who may have a concern about admissibility at the initial stages?
So, I mean, upfront medical, we tend to try to discourage that now because it's more complicated from a processing perspective for us to have a medical result in the system when we don't have a file to attach it to, because we don't have the application yet. And as I said, with e-medical, the results come much more quickly.
So essentially, I mean, the point is that someone could wait for up to seven years or more and then be deemed inadmissible based on their medical condition, right? That's what we're basically saying.
If the process takes that long in terms of what's the number of spaces in the annual levels plan, which then dictates how many visas we can issue in a given category any particular year, for example, and if there's unlimited intake, then that builds big inventories of applications like we saw in the Living Caregiver program.
We understand that is a timeline for some categories, right? And it's common knowledge. So getting on to the issue of excessive demand with respect to education, how does a doctor in another jurisdiction look at something like autism, and what kind of impact that'll have on the education at the school? And what kind of training does a doctor have to assess what kind of demand that they'll pose and what kind of support they may be, that individual child may require at the school itself?
Autism, as an example that you use, it's a spectrum disorder. One person could be a very high-functioning child. So it's not just, again, the diagnosis that will exclude them or make them inadmissible. So we look at the reports provided by the applicant from their specialist, like specialist, child developmental specialist, psychologist, school report. So those detailed reports are reviewed by medical officers, and we look at what frequency of services they require and what is the breadth of the services required. So it's based on this report submitted by the applicant in support of their medical.
Okay, so it's not just the medical examiner, him or her, that makes that determination.
That's correct. They don't make the final judgment. We look at all the reports, all information, and then do our analysis, and then come up with the detailed list of services, social services, special education plan, and then make our recommendation.
So potentially someone, a child with autism, just regardless of the spectrum, potentially the cost will exceed $6,300 a year, right? I mean, it's more so. while we may not exclude someone because of autism, but essentially de facto they're excluded because that is the cost of supporting that child through the school system.
Yeah, it's like any other medical diagnosis as well.
Right.
So if the cost of required services will exceed the threshold, they can potentially be inadmissible.
But I guess my point is, how many children with autism have we admitted in the last year?
I have a number here we can provide it to the committee.
Do you have it? If you can share it if you have it with you.
For autism, in 2014, there were 37 who were made inadmissible. 2015, 16. 2016, 23. So in total of 84.
The last 3 years. And then how many were able to provide support or were able to beat the threshold of 33,000?
How many were less than that?
Yes. Well, how many children with autism did we admit? Because these are the ones that were excluded,
yes.
Right?
Yeah.
So this is the first stage. This is the first stage of the adjudication.
This is the medical officer's recommendation,
right?
Which then goes through the procedural fairness process, et cetera, et cetera. And
so
that can take
how many
a bit of time. And we'd have to
been
dig in further to say, okay, for that particular line of recommendations, the 80-some in the
84,
last
you
few
said.
years, how many of those cases actually ended up in refusals or in admissions?
It'll be very helpful to have that kind of information for us, right? Because I think that's what we're trying to determine. So would you be able to provide how many of the 84 were able to go through the fairness process and were admitted to Canada? Okay.
I need to cut you off there. Sorry. Ms. Rempel and Mr. Soroya sharing.
Thank you. So my understanding is that there's actually two prongs to the component of excessive demand, right? There's the cost calculation that we've been talking about, and then there's the component around increases in wait times. Is that correct?
Yes.
So just to clarify, can somebody be deemed inadmissible on either of those two components, or is it if it's combined?
It's either of those two.
Either of those two. So we spent a lot of time talking about the first component of that today. I'm wondering, could you provide the committee with a breakdown on how many people, let's say over the last 5 years, that have been deemed inadmissible on the first category as opposed to the second category, like those broken down by those two?
Can we produce that?
I would say that often they're combined.
Okay.
So, whereas they're separate in the Act,
sure.
Often cases will actually meet the threshold and have a bearing on the wait time.
Okay.
But we'll do what we can to
So you may
apply
have
to
someone
that.
with chronic renal insufficiency, for example, who in the not too distant future is going to require a transplant,
Sure.
which then would have an impact on wait lists.
Yeah.
So
Perfect.
it can be either or, but it could be both.
It's often combined.
Can you maybe just elaborate briefly on how you would determine the wait time component? Like what criteria are used to evaluate that particular prong?
Yes. Wait times are published by the provinces. They're available publicly. So we look at the wait times. Those are mainly for surgical operations or transplants, those cases. So we look at the data available from the provinces.
What about, let's say, mental health services or those sorts of things? Would that be considered as well, or is it typically just for
it's typically for
surgical?
The surgical procedures.
Okay. So would like mental health services or care for complex or chronic conditions be included?
Usually those services, one can pay for them and defray the cost. So the wait time for them is not an issue more than the surgical.
Okay.
The definition in the regulations, the wait times is related to would increase the rate of mortality and morbidity in Canada. So it's not just any wait list.
Got it. Okay.
It's more specific than that.
Okay, great. So it would be like acute or emergent sort of diagnoses then?
That's correct.
Okay, great. Thank you, Mr. Sir.
Thank you. Mr. Said, or anyone of you, we know how many cases got rejected in 2014, 930, 2015, 713, and 16, 1101. There must be some sort of threshold when we say this is on the borderline, this is not too bad, this is good, this is we are going to let go, this is the final, we are not going to allow these people to come to the country. Against these numbers, how many people were admitted to the country? Do we have some sort of numbers?
No, we've undertaken to come back with those numbers, because those numbers represent the medical recommendation and not the final visa decision. So we will actually come back with those numbers.
Mr. Said, when a panel recommends somebody to admissible, how often the visa officer say, that's not too bad, I'm going to let this person go? Is there any chance visa officer reject the case from the medical officer? They allow these people to come to the country?
Ultimately, the visa officer has the discretion of making that decision, but they do consider the medical officer's opinion seriously and then look at that and will often discuss with us before making a decision if they are going to go against our recommendation.
Is there any cases they do overturn by the visa officer against the medical officer?
Yeah, they have the discretion to overcome that, and as was said earlier, that they can grant humanitarian compassionate basis. And
4 weeks ago, somebody came to my office. I didn't even know for this thing, but we are discussing today. There is a medical issue. They're not. It's I don't want to tell you what country this guy is from, but it was funny. He had his son has a number of issues, and he was okay with that. He understands the taxpayers' cost and all those things. I was surprised that this person was okay with this policy. In any one of your personal opinion, the today's system, does it work overall for the people?
Sorry, the what system?
In your opinion, anybody's opinion, today's system is working fine, or this system need to be upgraded? In anyone of you's opinion?
Well, we work with the legislative provisions that we have, and we apply the legislative provisions that we have, and if the government chooses to go in a different direction and we have different legislative or regulatory provisions, we'll apply those. So a matter of personal opinion isn't relevant.
Okay, got it. Message from Mr. Said. Mr. Said, if you can walk me into this. When somebody apply for a family or individual apply for the system to come to the country, when is the time when somebody get flagged, they say this person is not admissible? Who is the first person to flag that person? It goes to your panel or any other panels?
So the medical is done, as we said earlier on, by the panel physicians, which are designated by IRCC, but they're not IRCC physicians. Once the medical is done, it is sent to one of the 4 regional medical offices that we have, Hartward, New Delhi, Manila, and London, and it's reviewed by the medical officers at that RMO or regional medical office there. And then most of the medicals, if they don't have a serious or significant problem, they're passed. Only the complicated cases are then sent to this specialized unit in Ottawa called Centralized Medical Admissibility Unit, where we look at the file again and then make our recommendation to the visa officer. That's step 1. And then the applicant is given an opportunity to provide that mitigation plan through procedural fairness. Once that information is received by the visa officer, they send it back to us, and then we provide the second opinion, and then the final decision is made by the visa officer.
Thank you. Ms. Kwan for 7 minutes.
Oh, wow. Okay, great, cool.
and it's not even your birthday. You should see what you get when it's your birthday here.
Okay, I'm liking it more and more. Okay, I'd like to ask the officials to please confirm for me if the government uses Skykes Enterprises, a company based in Tampa, Florida, to determine the $356 on social spending in determining excessive demand. Is that correct?
There was some media coverage that talked about that company recently, and there was a bit of confusion. We have a subscription to a magazine or whatever it is they produce, and we actually look at that from time to time because they give us information about home care costs. But to my knowledge, that information has never been part of our baselining of the social services costs. That $356 that I referred to earlier.
So the information that I asked earlier on how the 356 was determined, so then we can get a full set of information on that. Okay, I'm going to ask then another question. Equally important is how do we calculate the amount in which the average Canadian spends in terms of social spending for people with disabilities. And so does the government, recently there's been information provided to Global News by the Conference Board of Canada, and based on provincial public accounts, which suggests the government does not take into account for nearly $27 billion in annual social spending by the provinces when assessing the limit for excessive demand. And that number could be as high as $40 billion if Canada's social transfer is included, or roughly $1,105 a year per Canadian, which would mean that the $6,655 limit for excessive demand set by the government could be at least $7,404 if all social service spending in Canada is accurately accounted for. And so I like to actually get the information from the government on how the government calculates the average Canadian's cost for those with disabilities, and to actually provide that information so that we can have assurances the government's calculation of the average Canadian cost is a complete set of numbers, an accurate set of numbers.
And thank you for that question, because it gives a good opportunity to clarify this misperception that's out there that was reported by Global News. As I said earlier, in our determination of excessive demand, we consider only a narrow basket of social services. And so things like social assistance, social housing, the majority of provincial expenditures on social services, because they're not directly related to a medical diagnosis, are not calculated into the threshold because they're not grounds for a medical inadmissibility. It's solely...
Okay, sorry, I'm going to interrupt there for a minute. Then I wonder if you can provide the committee the information on which how you calculate the average Canadian's cost with a disability and where you get that information from. If you can break that down for us, province by province, territory by territory, and how you calculate that, that would be appreciated.
What we can provide is the baselining for the basket of social services that we do assess. That is not a cost based on disability, but it is the total expenditure on those social services that are assessed as part of excessive demand, and then in turn divided by the Canadian population.
Do you take into account then on that information, for example, for provinces with special departments who provide for additional costs for people with disability?
We calculated the total cost as a baseline a number of years ago in 2004 and have been adjusting for inflation since that time.
So these figures have been used since 2004, and then you adjusted with inflation. So if we can get the information, the full details on how you calculate both sets of numbers, that would be appreciated, and where you get those numbers from, that would be appreciated. And also, I would like to ask if we could, with the information around numbers, if the committee could be provided with a complete list of medical diagnosis used to denied applicants. So the number of applicants who's denied for, I think, for the last 10 years, so that we can actually get a sense of what that looks like for each of the categories. So when I say each of the categories, they're the living caregivers, the economic class, and so on and so forth. That's what I mean by that. And then for those numbers, if we can get the reasons of why they were denied. I'm not asking for information per particular case, but in a group, so that there is no breach of confidentiality.
So there is a written question, Mr. Chair, that was provided to the department, I think it was October 17th, which covers very much the same territory. So we're working away at producing those numbers and that analysis as requested in the written question. I think what you've said, Ms. Kwan, mirrors what was in your written question.
Okay.
So we will be providing that.
Okay, and so for the information that we are seeking, Mr. Chair, I'm just wondering if the officials can give us a timeline on when we can expect to receive this information for the purposes of the work of this committee.
So we're going to need to look. I mean, there's a lot of lists of things that we've said that we will provide to the committee. So we're going to have a lot of people working really hard on that in the coming weeks. I hesitate to give you that'll be 2 weeks. Because some of this, I'm just not sure how much analytical work it's going to take to produce some of the numbers that have been asked for, but we will provide them as swiftly as we can.
Okay. And has anybody been denied, to your knowledge, on their application on the issue around excessive demand based on a disability of deafness or blindness?
Dr. Saeed?
Yes, again, if the deafness or blindness will lead to requirement of special services, social services for the child or for that individual, they can potentially be denied, yes.
Okay. Okay. So I would be very interested in looking at the information that's being provided on the reasons why people were denied. Do you also collect this data on the basis of those who were denied? How much did they exceed the figure of excessive demand to which the government uses? So do you have that information? And if so, can you provide that to us?
So we have a snapshot of the cases that we looked at, that 2014 caseload, when we were doing the analysis of what are the cost avoidance things for the provinces and territories. And so we have a breakdown of how many of the cases in 2014 were under $50,000 and up to over $500,000. So we have a breakdown of the number of cases that is in that very wide range.
I'm afraid I need to end you there. Mr. Tabera and Mr. Whalen. I'm not sure who's first. Mr. Tabera?
Yeah, I'll be sharing my time with Mr. Whalen. Thank you. I just wanted to clarify some things. So I wanted to get on exactly on who's exempt and who may not be exempt. So as I understand it in the statements, refugees that are applying to Canada, they would be exempt, correct, under the
Resettled refugees, yeah.
And then if a Canadian citizen applies for his or her family to come over with spouses, they're exempt.
Yes.
However, in the economic class, if someone is deemed medically inadmissible, they're not exempt from that. If they have a certain health condition, then they wouldn't be exempt, correct?
Yes.
So I have an article here at the Toronto Star where a York University professor has been denied because of her 13-year-old son had Down syndrome. So this is part of the economic class that I'm getting at, is that we have an individual that has a good profession, is a professor at a university, etc. But one of the children has a health condition, and it makes the case denied. Is there not some way that we can have something going forward, a policy that we can see some changes where that we can allow some of the leniency and acceptance to the family? Because I think we should measure the contributions of the family as a whole and not really target one individual in the family and then have the whole case thrown out and denied. Can you elaborate on that?
Well, so, part of the fundamental policy review will cover these kinds of questions, And have we got the balance right that I spoke of earlier in terms of trying to protect publicly funded health and social services versus the humanitarian side, the compassionate side, et cetera. And so those kinds of things will be factored in, and certainly, you know, if the committee were to make a recommendation in this regard, then that would be factored into our thinking as well.
And just really briefly to add to that, you mentioned strike a balance. Have we been engaging with the provinces to strike that balance as well with them?
So when federal, provincial, and territorial ministers met in October 2016, and they jointly made a commitment that we would be looking at this world of medical inadmissibility, because if there were to be changes and possible impacts on the provinces and territories who administer the health and social services, we wanted to make sure that we actively engaged with them. We sought their input, we sought their feedback, and so that's been happening since October 2016, so over a year now, or about a year now.
Thank you, and I'll pass on the remaining time to Mr. Whalen.
Thank you very much, Mr. Tavera. Okay, so again, I'm trying to wrap my head around this, and so thanks for teaching us. So there's the category of a danger to public health, and if someone comes forward and there could be a danger to public health, their application could be delayed, in which case they would receive treatment, or could be denied outright, presumably. Then there is a danger to public safety, and again, if it's something that could be treated, it'll be treated, or they could be rejected. And then there's this third category of excessive demand on health or social services. And under that, we have a couple of different interrelated definitions. One is this above the average healthcare cost threshold. And the other one is the demand on health services or social services that would add to existing wait lists and would increase the rate of mortality or morbidity. And I'm trying to see how this could be quantified. Do you have particular metrics that you use, and how do those interplay? And in the data structure you use to assess applicants, are there particular fields within that data structure that go into whether or not this person is going to be increased wait times or increased morbidity or increased mortality, or I guess it would be reduced mortality, but whatever the bad thing is on mortality? Are there particular line items within the data structure for the applicants that go on these things together? And would it be easy for the department to assess rather than on individual by individual, family by family, or maybe just exclude the children altogether? I know it's a long-winded question, but maybe we can talk a little bit about how this data is presented to the department and stored. And
so I think this question was partially answered before as well, but I'll repeat some of the parts of that. Again, we look at the reports provided by the applicant and the severity of the condition and the needs for services, what frequency that they require. So an individualized approach is used because courts have told us again and again that you have to review the application or applicant individually, not as a generic diagnosis-based assessment. So we look at the diagnosis, we look at the prognosis for next 5 years, and what type of services are required for that particular individual.
okay, and again, with this category, is this like a definite no, or is this one of these ones where it could be wait and see and delay your application until your condition isn't as severe?
They are provided an opportunity through procedural fairness to come back and tell us if they are going to defray the cost of these services. So
Okay.
It's not delayed. It's delayed in the sense that they're given the opportunity to give us the mitigation plan.
Okay, so I'm not sure, Ms. Kwan asked for a lot of information, but I'd like to make sure that in there, it's not just rejections, that we're getting information on the people who are impacted by this test. So of all the 360,000 or 550,000 medical exams you look at, you know, what percentage of them do they trip the threshold of an issue or additional concerns regarding rate of mortality and morbidity? Like, when does that, I'd like to have a sense of how often does this become an issue for the assessment, and how often, you know, an interaction has to occur as a result of that, just to make sure we get there.
Part of the.
Yeah.
And then on families, in terms of the type of regulatory change we would need to make sure that children aren't subject to this, what would the department recommend in terms of regulatory change? Is it just these definitions, or are there other regulations we would have to look at if we were going to make children exempt from this?
mean, that's then getting into what I referred to earlier as the awkward situation of officials speaking to policy advice that we will give to the government. So it's difficult to answer that question. There are various mechanisms that can be used in either redefining some of the services, in redefining what excessive demand is, in creating other exempt categories. There's all kinds of things that could be looked at as part of this.
Maybe
I need to end you there, and I can just hope that the officials will read our report, because I suspect that's what we'll be giving to you. It's exactly what Mr. Whalen is asking from you. Mr. Soroya, Mr. McGuire.
Just have one question, Mr. Chair. Talk about the fairness. All these inadmissible people, all the rejected cases, 2014, 2015, 2016, with all the fairness, can you provide us the list of what country these people were rejected and what reasons? Is that possible?
Yes, we've already discussed that, and so we've got the list of the cases where there were recommendations made by a medical officer based on services related to particular conditions. We have that list. And then we need to do the digging to see, well, what happened next in terms of the actual cases themselves.
If I can add something else, with it, is there any country where have zero problems? Everybody gets to come to the country, get zero rejections based on the medical or anything? Can you provide us the information on that as well, please?
Sorry, I'm having trouble understanding the question, Mr. Chair.
Is there any country they have zero problems, have no problems bringing all their citizens here for any medical reason or any other reasons?
Okay, so you mean the nationality of the applicants? Yeah,
Yes.
so we did, I think, already say that we would have a look at what is the nationality of the applicants that have been found to be inadmissible.
Thank you.
So that, I off the top of my head, I can't say to you, Americans never have problems with medical inadmissibility, because I think that would be a ridiculous statement. So,
No problem. Larry McGuire, thank you.
Yeah, thank you. In the presentation today as well, under the excessive demand considerations you were talking about, of course, it's determined by a departmental officer, usually referred to as a visa or immigration officer, you were saying. And then you referred to as opposed to what happens in the U.S. or some other countries you mentioned. I just forget where else it was. Can you quickly elaborate on that? And then I've got one more question.
So for the decision makers under our legislation, the visa officers are folks who make the decisions overseas, and the immigration officers are the folks who make the decision in Canada for people who've applied for permanent residency from within Canada. So that's the distinction there.
Okay,
and I'm not sure about the reference to the Americans. We did talk about Australia and cost net benefit stuff.
And to our understanding, the United States and United Kingdom use an approach that is much more dependent on independent decisions by their equivalents of visa or immigration officers. They do not have a threshold-based system like we do.
That's more, I guess, what I was referring to. So you don't hire these physicians. They're a monitoring physician. And do we have offices in Canada that deal with it on a first and an upfront basis, or is it only after there's a concern that it comes back to the Ottawa office?
So for the panel physicians, they're impaneled by us and assessed by us to make sure they meet our standards, and they're all over the world, including in Canada. But they're not employees of the Government of Canada. Mm-hmm. And then we have our own medical officers who are in 4 different locations, London, New Delhi, Manila, and then here in Ottawa. And since only 0.2% of our cases actually end up clicking over into, we think there might be an issue around medical admissibility, that's now in a centralized medical unit for the last several years, where the medical officers who do that work are only in Ottawa.
Thank you. And the last question I have is, you gave us a number of $33,275 as of January 1st, 2017 as a public funded services over 5 years, sort of the average per capita cost that you use as a benchmark. So that breaks down to about $550 a month from my math on this one. So is it a rule or kind of an objective that you have that the government covers that first amount of $550 a month, And I think you mentioned that if the individuals could cover the costs over and above that, that they would be allowed, more likely to be allowed to stay as well. Is that a fair assessment?
Yeah, I mean, we don't look at it from a month-to-month cost. We look at it in terms of that 33,725, 275, sorry.
Yeah.
I mixed up, made my numbers go backwards. We look at that as the cost threshold, and then we see in terms of the services that the individual would require of a health nature or a social nature, what the cost of those services actually are, and does it take you over the top in terms of the threshold. So I would posit that if someone had a condition that their costs were $33,276, I don't think a visa officer would say, okay, that's it, we're done. There really are costs that are far above the cost threshold.
We need to end there.
Yeah, I just, if I could say, I just noted it was an average, and that's why I was wondering. Yeah, thank you.
Very good. Ms. Zahid.
Thank you, Chair. Further to what Ms. Kwan was referring, the article, the Global News story on July 4th, in that report, the Statistics Canada said, with our current data sources, it would be difficult to quantify the value spent on the social assistance programs targeting this specific group in the population as defined by IRCC, specifically with regards to persons with disabilities. If Stats Canada doesn't think a real figure can be calculated, is it really fair to reject someone's application based on incomplete figures?
So we'll go back to the 2004 baseline activity that we engaged in. We identified what wasn't covered in the Canadian Institute of Health Information's overall number as compared to our definitions in our regulations. And then we did a study by talking at the time to Statistics Canada, to Health Canada, to getting data from provincial officials, to then come to that baseline idea of what is that package of, that basket of social services, and what are the costs of that. And that's the number that we've been using and updating with inflation year over year. So Stats Canada today may say we have difficulty doing that. Well, at the time, they provided information to us as part of our baseline study that they must have been confident in and provided to us. Michael?
And to be clear, it's a bit in how you ask the question. Global News asked Statistics Canada if they could quantify the total services provided to persons with disabilities, but we're not actually assessing against the total costs of all services provided to persons with disabilities. We're assessing against a specific basket of services that's specified in the regulations.
We have talked a lot about the people who are coming permanent residency, whether under the economic class or the family reunification. I would like to get some numbers on the temporary resident visit, or like people coming on TRVs, because when they apply, they don't have to go through like medical examination, or they don't need to submit. Do we have some numbers? Like, were some people when they landed at in Canada, were they rejected, or like because of the fact that the visa officer thought that they are medically inadmissible? Are there any cases in the last few years?
Yes, so not all temporary residents have to go through immigration medical exams. There's a small subset of those. So they're individuals, for example, if they're headed to work or study in areas where public health is very important. So if someone is coming to Canada to work in the medical profession, for example, even if that's only temporarily, they will go through an immigration medical exam. We also look at temporary residents who are coming to Canada for longer than 6 months, and if they come from a country that has a high incidence of infectious disease like tuberculosis, people from those countries, if they're coming for more than 6 months and they've lived continuously in that country for a year, then we have them go through immigration medical exams.
No, I'm talking about those people who don't have to
there
go
are
through
people. Yeah, sorry. There are people who do not go through immigration medical exams to become temporary residents, who later go through medical exams as part of the permanent residency process, and at that point are discovered that there's a health condition that would cause an issue from a medical inadmissibility perspective.
No, I'm saying that if someone is coming here on a temporary resident visa for 3 months to visit their family, like if the parents are coming to visit their grandkids and their kids, like, has there been any case of those being determined as medically inadmissible when they land in Canada? Do we know of any?
Not to my knowledge. I mean, they wouldn't have gone through an immigration medical exam. If they came off the plane and clearly had, something that would be of concern from a public health perspective, there's quarantine provisions that would apply, but I don't think that's what you're talking about.
I will share my rest of my time with my colleague, Mr. Evans.
Thank you. Picking up on something you had said earlier with respect to the provincial nominee program, you had suggested that one particular instance, the province kind of required an individual and you were able to work with the province. What other ongoing conversations do you have with provinces, and what kind of cooperation do you have with provinces where some of the rigid requirements as outlined can potentially be overridden?
For privacy reasons, we don't tend to have conversations about individual cases with the provinces. I raised the example of provincial nominees because clearly those are cases the province knows about and that they've provided a nomination certificate to, and then they become aware that there is an excessive demand angle to the file, and then they reach out to us.
Okay. I need to end you there. Well, one more, quick.
So do you have ongoing conversations with the province with respect to the threshold? Or do you have any input from them with respect to establishing the threshold?
The threshold is determined on a statistical basis based on national data, and so it's not something that the provinces feed into. We have had conversations as part of our fundamental review with the provinces, as Ms. Edlund referred to, following the discussion at the level of the FPT ministers responsible for immigration. There have been working groups and discussions around that in terms of helping them to understand the provision and to understand the potential impacts that any changes might have on their systems.
Thank you. Ms. Rempel.
Thank you. So just to clarify, right now the medical inadmissibility category is only applied, it's not applied, for example, to people who are coming in as government-sponsored refugees. Is that correct?
That's correct.
Because they would already be getting a permanent resident status. Do we track within the government-sponsored refugee class utilization of Canada's healthcare service at all at the federal level?
Yeah, so for government-sponsored refugees who come into Canada, like the Syrians, for example, they are landed as permanent residents, and so they have an automatic qualification for provincial health services. But then our interim federal health program tops up healthcare services that they are not covered for under, say, under OHIP.
And for
a period of a year.
For a period of a year.
While we're giving them the income support.
Okay, and then after that point, there isn't any more top-up, correct?
Right, yes.
Okay. So, ostensibly, if this committee is looking at recommendations around whether or not to change the formula for medical inadmissibility or whatnot, obviously, cost and burden on the healthcare system in the provinces is going to be a consideration. Do you think it would be possible to provide the committee with some sort of estimate or some sort of analysis on the estimated increase in cost past year one of, let's say, the Syrian refugee cohort? And just for my colleagues opposite, my line of thinking is this: if we're going to look at amending the formula or recommending that, we have to also look that if the government is going to take in larger cohorts of government-sponsored refugees in shorter periods of time, we have to think about the cost to the healthcare system that compounds over that period. So would it be possible to get some of that data just to sort of include in our report?
So I'll start, and then Michael can jump in.
Okay.
It's not something that we have a great line of sight on in terms of what Syrian refugees may use after our interim federal health top-up stops.
Okay.
We are working on information sharing agreements with the provinces to try and get information about social service usage, health service, educational services, employment stuff writ large. But that's not to do with medical inadmissibility, right?
Sure. So maybe just for lack of that data, could you provide us with the data that you do have for the utilization and top-up around the year one? Mm-hmm. Because you would have, that would be fantastic. And then
I'm just going to caution the member to make sure we stay within the parameters of this study.
sure, and that's why I was laying out my logic on that specifically for that reason, right? Because we're looking at overall cost. Then going back to my previous line of question around the weight on or the demand on wait times, has it always just been applied to surgical or acute conditions, or has there been any thought as to looking at the definition in terms of potential wait times, specifically for mental health services? We know that there's a long wait time for people to get access to mental health services, let's say, or other chronic medical support. Has there been any discussion or in your consultation around expanding or reducing the definition for burden on wait times?
So that's getting into the policy discussion angle again. But if there were to be such a discussion and recommendations were made or decisions made, we would need to be amending the regulations that refers our wait times is only in relation to mortality and morbidity.
Okay.
So a mental health issue and a mental health wait time isn't one that's going to run into that mortality and morbidity issue.
So right now, if somebody presented and was evaluated that had, significant mental health support requirements, that wouldn't be evaluated or considered in the medical inadmissibility determination at this point in time?
Not in terms of a wait time.
But in terms of the cost?
But in terms of the cost, or if it's a mental health issue that causes someone to be violent, for example, then that may come into the public danger angle.
Great. Larry, Bob, did you have any other questions? Okay, we're done.
We have 2 minutes if Mr. Sari would like to go.
What occurs when new information is brought forward by an applicant? What mechanisms are there to place to reopen an application if it's been denied based on a medical opinion? Is there a way to reassess that?
And the case has actually been refused? Is that?
Yes, or originally the medical officer has ruled that it's past the $33,000. And somebody has now new evidence. For example, they're going through chemo or cancer treatment, and now they're past that, or perhaps they're on a spectrum on autism, and they've now managed better, and they don't need these services as much. What would be the procedure?
That information is sent to medical officer via the visa officer, and we look at the validity of that information, and if the treatment required for that person is completed and they no longer is going to cost above the threshold amount for the next 5 years, they can be made admissible after that. A case, an example is somebody who has hepatitis C. So there's treatment for that, which is very expensive, about $70,000 to $80,000, but it only lasts 12 weeks. So, and they're deemed cured after that. So they can submit documentary evidence to us that they have gone through that treatment in their country, and provide lab reports to confirm that, and we will then send our new opinion back to the visa officer.
And if one is, I had a case in this situation where a child required some abilities, special needs for schooling, and the father had offered to pay for private schooling that offered those services. And this is something I believe he was refused on, but is there a bond requirement when somebody commits to giving services in Canada, or is it just a financial ability to show? What's the requirements when somebody says we will be able to mitigate that cost on Canada, or they're willing to pay for it? Is there a possibility of doing a bond? I know there's currently not. And is there a possibility of any other way for someone to show that they would mitigate that burden in Canada?
Very briefly.
Okay, very briefly. So that would be part of the mitigation plan that the family would put forward in terms of saying we won't access these services because we will do X, Y, or Z instead. And our medical officers will look at that and evaluate it as a practical plan. I mean, if for example, they said, well, we won't access special education services because we won't send our child to school at all. Well, that would be a plan that we would say that's not a plan in terms of overall Canadian morals that we would find acceptable. But in terms of the mitigation plans themselves, if that then turns the switch off on the medical inadmissibility concerns, there is nothing in authorities that we have to enforce that mitigation plan once someone becomes a permanent resident.
I'm just going to turn to Ms. Kwan for 1 minute.
I have 1 minute? Oh, okay.
We're at the end of the meeting.
Oh, okay, thank you. I just want to clarify on the question around collecting the data and providing the data back to the committee for the people who don't qualify based on the number, the amount to which they exceeded the acceptable government rate of excessive demand. Can we get that number broken down by increments of $500? So we don't get the information to say, you know, within $50,000 they exceeded this amount, so therefore they don't qualify, but rather a smaller amount so that we can get a fuller sense of who's being rejected in smaller increments. Because I know of one case where a immigration lawyer came forward to say that her client was rejected because they exceeded the amount by $400. So I would really like to know to see how much people are being rejected by and how much did they exceed the amount.
Yep.
Thank you. That draws a close to our meeting. Committee, in my head, as this meeting has progressed, my sense is that each of you have probably got some new questions you didn't have before this briefing, and I'm going to talk to each of the parties that if you have a new suggestion for a witness that you would like to hear from because of the testimony we've heard today, I think we will entertain that, because I think some issues that maybe StatsCan has been referenced here, we don't have a witness there. We've had some provincial nominee issues raised. I just think I'll go back to each of the parties, and if you've got some new request for a witness based on this testimony, I think that would be helpful, because a lot has been raised today. Ms. Kwan?
Thank you very much for that, Mr. Chair. I really appreciate it. And on that score, I think one of the officials mentioned that the minister is going to be coming to this committee on this issue. And if that's the case, I wonder if the committee can get the information that we requested prior to the minister arriving, because that would be very useful and helpful to have that information, so we're not tempted to repeat our questions to the minister.
Absolutely. What I think, for fear of changing the definition of excessive demand for what we've given to the officials to do today, we're going to have to, we'll work out a timeline with what's reasonable in terms of your ability to get us that information. We may need to adjust our study time, because you've asked for an awful lot of information today. And I'm just going to work with the clerk and the analysts on a timeline, because I have a feeling, and this is my usual instinct, is that once we've heard from the officials, now is the time to truly scope the study, because I think you now have an idea of what is involved in this study. So we're going to just take a breather on. We've invited provincial officials to come on Thursday. We haven't had an overwhelming response, so stay tuned on that. And then we go on to the Ziti briefing next week.
Report next week.
Report next week. Yes, report next week, and then the Yazidi study. So we have a little bit of time to make sure that we have the officials give a chance to get back to us, and then we'll look at where we are. But so if the parties would each think about anything from today's testimony that you think we need someone from civil society or another departmental official from a different department to come and talk, we're going to entertain that. Okay, until we see each other again. Meeting's adjourned.